Supreme Court takes on racial gerrymander claim in Virginia. The Supreme Court will delve into the issue of racial gerrymandering Monday when the justices review a lower court opinion that struck down Virginia district maps as a violation of the Constitution. At issue are 11 maps drawn by the House of Delegates in 2011 that were successfully challenged by registered voters in each district. The case, which has been tangled in the courts for years, comes on the eve of the next census, after which new maps will be drawn. As such, it's the second time the justices have reviewed the case. 2 terms ago, unlike the issue of partisan gerrymandering, the Supreme Court has settled on a standard to determine when states go too far in considering race. The court has said that, after fresh review and a new trial, the lower court held that the plaintiffs have registered voters from each district, represented by election law expert Mark Elias, who served as the general counsel for Hillary Clinton's 2016 presidential campaign, argued that the consequence of the maps, Elias argued in court papers, was that African American voters were crowded into the districts at issue so that their votes were diluted in surrounding areas. The legislature sought to achieve an African American voting age population of at least 55% in each district. In briefs, Elias said the House of Delegates had imposed a non-negotiable 55% black voting age population floor across. In striking the maps, the lower court held that the legislature made but a lawyer for the House of Delegates argued that the lines had been drawn utilizing traditional redistricting factors including compactness, contiguity, and a respect for political subdivisions. In addition, when the maps were drawn, Virginia was a covered jurisdiction under the Voting Rights Act that mandated the legislature draw maps that would not result in retrogression of a minority group's ability to elect its preferred candidate. Paul Clement, a lawyer for the House, argued that legislators widely. Clement argues that the legislation is walking. One issue that might stop the justices from getting to the merits of the case is whether the House has the legal right or standing to bring the case in the first place. The Trump administration argues the House does not have standing because a Virginia law says that only the state's Attorney General has the right to bring the suit. The Attorney General, the government argues, however, that if the Supreme Court were to reach the merits of the case, it should vacate the lower court opinion.
Raindrop, drop top, smoking, no cooking the hot pot. Fucking on your bitch, yeah, that. Looking up, open the park pot.